obliged, my lord. My lord, on bench, I hope each of your lordships has a file. It's got behind numbered tabs what we think are the relevant sections dealing with the status post-Brexit of the Charter and of general principles and of supremacy. I wasn't proposing to take your lordship back through
That's fine.
through that again, but that's got the material. If we need to look at it there, then we can. And the other thing I was just simply going to mention is in relation to the question that your lordship raised about dates upon which appeals and applications were notified to the tribunal. It seemed to us a practical way of dealing with that. We have checked. We think everything was notified or appealed prior to 31 December 2020. We've looked at the documents. My solicitors will email from Mr. Hewitt's team now or very soon after now and see if that can be agreed.
Okay.
So that hopefully will resolve that, at least for the lead appellants. Can't of course speak for every entity that might be a stayed case or whatever, and it may be that might have to be looked at in the light of what this court decides, but that seemed a practical way of dealing with.
So what you've checked is on test cases rather than stayed cases?
Yes, because there are, I think we're well over 100 of the state cases.
Incidentally, on that question, you've helpfully referred us to Schedule 8, paragraph 39 of the 2018 Act. Is there any definition of proceedings for that purpose?
Not that comes to my mind. Which isn't to say that
because the key words are any proceedings begun before a court or tribunal in the United Kingdom. So
I'll double check.
I've no doubt that at all that the FTT is a tribunal, but what is a proceeding for that purpose?
Yes, well, if there's any further help we can give, we'll supply it. I hadn't alighted on anything in the time that we've had since the question arose. But if there is any more to be said, then we'll make sure it is said before the time finishes. Lord, I was on issue 6, and I was just going to deal in very summary fashion with the factual position. That's in the Upper Tribunal 179 to 181, top of court, page 181. Dealing with Avon Insurance, as the name suggests, it's not an investment fund. The relevant accounting period, that's 1997 to 2003, and Avon had received portfolio dividends from non-resident investments. As the UT records, reflecting what the FTT had found, Avon included that income in the computation of taxable profits. It claimed credit for withholding tax only. And those accounting periods, 97 to 2003, they are now closed. And so that's why issue 3 is not relevant to Avon's case. The reason issue 6 arises is that on the 8th of November 2018, so that was following Prudential Supreme Court, Avon wrote to the Revenue making a claim to adjust its double taxation relief on the basis of the foreign nominal rate. And just for your note, that letter is in the supplementary bundle, tab 10, page 71. The question's whether that letter constitutes a claim that's in time, because the Revenue's position, and this is recorded just for your note by the first tier, para 90 sub 40, the Revenue's position is it considers the claim to be out of time, so not a valid claim, but to the extent the claim is in time, then there's notice of intention to inquire into the claim. And so procedurally, it's Avon's application to close that inquiry. And so what the first tier determined was that there was an open inquiry because it held that section 806 sub 2 was engaged, and a claim had been made within the 6-year time limit because that ran from Prudential Supreme Court. That was FTT paragraphs 152 to 161. That was overturned by the Upper Tribunal.
So did they direct closure?
Yes, they
notice
did.
then?
They did.
And the Upper Tribunal overturned?
The Upper Tribunal overturned.
Suspended, I think, wasn't it?
Oh, my learned friend rightly reminds me because the revenue appealed, the closure notice direction was effectively suspended pending the revenue's appeal. So the closure notice was not required to be issued. Overturned, and if one looks at Upper Tribunal 191, essentially that's on the basis of accepting the revenue submission that there was no adjustment of the amount of any tax payable. And so that led the Upper Tribunal really to say, well, whatever is the position in relation to other issues, the claim was too late and the FTT should not have directed the revenue to issue a closure notice, so there were no valid inquiries which HMRC should close. So I'm going to deal first with the point where the Upper Tribunal found against me, that question of adjustment of tax payable, and then of course I'm going to deal with the other conditions for 8062 to apply. My submission, and this will be common across all of the questions relating to this issue, is that the answers are driven by the conforming interpretation, which we now know is to be given to section 790. And we know, perhaps we should just turn this up, going back to Prudential High Court, Authorities tab 30, which is at the front of volume 3. Paragraph 103, which is page 754. The conforming interpretation is to construe section 790 as providing for the grant of a tax credit for foreign dividends to the extent necessary to secure compliance with EU law. And that, of course, brings in the dual credit as described in Prudential High Court. We have to read that dual credit into section 790. So we're reading section 790 as providing for that credit. And we know that where 790 went wrong was in 790 sub 4 to sub 6. That's what I showed the court yesterday morning. What this court's judgment in Prudential makes clear is that other provisions then take effect in accordance with their terms. And I should show you how that played out. In Prudential Court of Appeal. And that's still in volume 3, tab 34, starting at page 858. And the principle which the Upper Tribunal accepted, but which in my submission it then misapplied when it comes to looking at these later issues, is the principle in paragraph 109. And I fully accept that this ruling is made in the context of advanced corporation tax in section 231. But there's no difference of principle, point 1, between ACT and D5 here. And secondly, I will just show the court an example in FI Court of Appeal of the same approach being taken for D5 tax, just if there's any doubt to reassure the court. The principle's in paragraph 109, and it's the final sentence that once the conforming interpretation is applied, the other, in that case it was the ACT provisions, but the other provisions simply apply in accordance with their ordinary meaning. And that's because there are no wider arguments of the sort that I've been developing in relation to my ground 1 points. Can I just show the court the context in which this issue arose. If one goes back to paragraph 81, page 880, this was all in the context of a large debate in Prudential about how it was that one should identify unlawful advanced corporation tax. And you can see that at the start of paragraph 81. And there were various arguments as to whether this was open to the revenue, and then whether, as a matter of substance, it was right. And this court concluded the points weren't open. That was paragraphs 89 and 90. But what the court then does is it goes on to deal with the merits of the point, and that was 91 and following. They thought it was necessary to do that. And that ruling, as it happens, was later then applied in FII. The competing arguments are set out in 92. So Prudential says, and this is by letter J, look at 2311, construe it in such a way as to grant a tax credit for foreign source portfolio dividends. That creates a modified FII system, and the tax credit is treated then as part of frank investment income when you look at other provisions. And then the revenues method was rather different. It had been summarised below in a passage set out at paragraph 93, and then that's further summarised in 94. It wasn't applying the FII system, i.e. the existing provisions. It was proposing a different system, a completely different system, to calculate the amount of overpayment of tax by Prudential, and that involved identifying different income streams and then working out how much of the profits derived from UK source dividends and how much from foreign source dividends. And then the provisions are set out, and the court notes in paragraph 99 towards the bottom of 884 that the overriding requirement, that's for equivalent treatment. And this is in the context of the ACT provisions, reading in the relevant credit. And then 100, the question then is how that credit should be given. Prudential's approach, simple modification of the existing system. And the court says, well, actually, the decision in FICA 1, that's given the answer, that's 101, and Prudential are right. And as it happens, it's at 103, that's the point I made yesterday, where this court notes that the observation that it was conforming interpretations that were in play in FICA 1, that wasn't quite right, but nothing turned on that. And the court had held that conforming interpretation was possible, that's the first sentence of 104. 105, what does that mean? Modify the interpretation of section 231 applying my leasing. So you create the tax credit of the relevant amount in respect of foreign dividends. No other change to the interpretation of the ACT provisions in accordance with their ordinary meaning was suggested, and none is necessary. And that's why I make the rider in particular that this issue, different considerations arise in my submission to the issues that I was addressing yesterday and then this morning. I won't go into what's said to be the simple example, because these things have a habit of complicating themselves quite quickly. 108, so that the solution followed from FICA 1. And then 109 is the point I've shown court already about how once the conforming interpretation is applied, the other ACT provisions simply apply in accordance with their ordinary meaning. 110 records the revenue submissions, that actually a different approach was appropriate. And that allowed a distinct methodology to be introduced into another submission. That's rejected in paragraph 111 on the basis that it rests on a misconception as to the operation of the mar-leasing principle. And this is important. Just above C, application of that principle, so that's mar-leasing, doesn't make it irrelevant which particular statutory provision in a group of provisions is being interpreted. It's a principle of interpretation which is applied to give a specifiable and specific meaning to a particular provision or series of provisions taken one by one, even if it allows considerable latitude as to the wording which may be read into the provision or provisions. And then reference is made to the grain of the legislation. And the point is made that the interpretation was sufficient to give effect to the taxpayers' rights to free movement of capital, actually because other provisions continue to operate alongside 2311 as so interpreted, is as conformingly interpreted in the usual way. That's what the court means when it says nothing was left at large. And then 1112 is further problems with the revenue methodology, which needn't detain me. And so the important point when we look at how this plays out as between 790 and 806 sub 2 is we need to give specifiable and specific meaning to section 790, that's point 1. And then the other provisions apply in accordance with their ordinary meaning. And I said there was no magic about this being to do with ACT. The best example I can give to make that good is this court's treatment of an issue that was referred to as the blending issue in FII Court of Appeal 2 in 2016, which is in the same volume, tab 37, starting at page 925. And this was issue 2, and in both before Launcelot Henderson, who'd had the case at first instance, and it's still issue 2 in the Court of Appeal. It's headed up, what is the appropriate foreign nominal rate, above paragraph 88 on page 946. And I'll try and keep this as simple as I can. In FII, in only very few cases was the dividend actually paid out of profits made by the company that actually paid the dividend, the so-called Water's Edge company. That's the point that's made in 88. And if you had that simple case, the appropriate foreign nominal rate would be the FNR applicable to the Water's Edge company. But 89, usually actually profits had been made lower down the corporate group. So you've got to work out what is the appropriate FNR to apply. It's obvious we've got to give FNR credit, but how are we going to do it? And the three possibilities are set out in the case of these mixer companies. So either use the FNR of the foreign Water's Edge company, as it happens, that was the solution endorsed in Prudential High Court for portfolio dividends. Or do you do a weighted average following the system set out in section 801? That is the solution that's ultimately adopted both at first instance and then endorsed by the Court of Appeal in FII in the context of controlled holdings. And then the revenues approach was little c, dig down and disaggregate. And in choosing between those solutions, so first of all, below, paragraph 93, it had been found that the first solution, so just looking at the Water's Edge company, that should be rejected. So you've got to look at the jurisdiction in which the distributed profits were in fact subject to tax. So that got rid of little a.
No, that applies to portfolio.
Yes, it does. I'm simply, and
Yes, I know.
I'm just doing this as an illustration, my lady. That's right. It does apply to portfolio dividends. essentially as a function of effectiveness, if one looks at the analysis in Prudential High Courts. It's another example of the general principles actually conditioning the conforming interpretation. I can give you the paragraphs in a second for what actually happened in Prudential High Court, if that would be useful. And then 96 sets out the reason given below for preferring what was called Solution B. And that was because it took the UK system as it actually was, and it made only such modifications to it as are appropriate to accommodate the ECJ's ruling. Whereas the revenue had started from first principles and then tried to work out how far you could lawfully impose a charge. And then 97, the explanation was that the methodology built on and adopted the machinery under Section 801. They don't actually refer to Section 801 here, but I'll show you what it now says. It's been amended, but 801 uses a concept of tax payable. And so the FNR credit, it had been found, should be applied using the mechanism in Section 801. And the reasons, and we'll see that this court endorses these reasons that are set out at 98, for preferring the claimant's alternative case are essentially because the question of the unlawfulness of the Case 5 charge doesn't arise in a legislative vacuum. So you've got to look at the actual tax system that was operated. And that's got to be applied subject only to what's required by way of disapplication of conforming interpretation to make it EU law compliant. The claimant's approach, that adapted and built on the existing machinery. And then 99 is the revenue submission. That was the wrong conclusion, said the revenue. And there were various examples and points made in support of that. But this court deals with the matter by way of principle, as you can see at paragraph 103. The answer depends on the correct approach to arriving at a conforming interpretation of UK law to ensure compliance with EU law. And then 104 sets out the basic principle. 106, the need to go with the grain. 107, it's still a process of construction, it's not legislation. And then 111, the very broad approach for which the revenue were contending, so that's disaggregation. That went far wider than anything previously accepted as a conforming interpretation. It's contrary to authority. So the vice is they weren't proposing an interpretation. It was introducing a scheme not in the legislation, whereas the claimants were adapting an existing provision regulating tax credits. And the court in FI, Court of Appeal 2, they apply the approach I've just set out in Prudential Court of Appeal. You see that in paragraph 112. And then at 113, the approach that had been taken below, that was endorsed. So what that's doing is applying the same approach that was taken in the context of advanced corporation tax in Section 231 in Prudential, in the context of D5 tax and Section 801. And the version of Section 801 that we have in the bundle, it is the amended version, so it wouldn't, this wouldn't have played out in quite the way as it applied for many of the years at issue in FII, but both as amended and as it was previously enacted at page 72 in the authorities, what is being taken into account is tax payable. That's the relevant concept. And that, as it happens, matches the concept that's being used in Section 790. And that concept is being used even though what is being given effect is credit at the foreign nominal rate. And so if we can look up Section 790, which is in Authorities, Volume 1 at page 40 in tab 7, one has to look carefully at what Section 790 is doing and how it fits fits into the remainder. One has to take into account what Section 790 is doing and how it fits into the remainder of the double taxation relief code. As you can see in 790 sub 1, that what the following provisions of this section are doing is that they are giving credit in respect of tax payable under the law of any territory outside the United Kingdom. And that notion of tax payable is a concept that is used repeatedly elsewhere in the double taxation relief legislation.
Yes, you put a lot of reliance on 790 sub 1.
Yes, I do.
But just looking at section 790 itself, subsection 1 really introduces the following provisions of the section.
Yes, that's right.
As I think you've already accepted, the key provisions that actually confer relief are
4 through to 6. Or the key provisions, yes, the key provisions that gave relief under the UK system as originally enacted are 4 to 6, and
Yes.
they are the ones that have to be subjected to the conforming interpretation.
correct. And for what it's worth, which may not be much, they do not, to the extent you're putting a lot of stress on the expression tax payable, those subsections do not refer to it.
No, but we're told in sub 1 that everything that follows is a credit in respect of tax payable. So the credit in sub 4 is a credit in respect of tax payable. So we're told that in sub 1. And similarly, the credit for withholding tax that one gets through 5C(1), that is also a credit in respect of tax payable. All of 790 is a credit in respect of tax payable. And you can see the concept being used, for example, in 801, as I've mentioned, on 72. And the concept also being used in 806 sub 2 itself. And that's why, I think in the skeleton I say 790, you can see it in sub 1 as something of a definitional provision, because it introduces a concept that is picked up and used elsewhere in the legislative scheme, because those other provisions in part 18, they're picking up whatever the credit is given under section 790 through a concept of tax payable. And in my submission, we know from Prudential paragraph 103 that we have to read into section 790 the additional credit required by EU law. And we know that that's credit at the foreign nominal rate. What that requires is when one looks at that concept of tax payable, that concept must be interpreted in a way that accommodates the FNR credit. Because otherwise, I ask rhetorically, how can it be that, for example, the machinery in section 801 is actually going to be made to work? 801 was using a concept of tax payable. You can't say the FNR credit is doing something different, because if it was, it's very hard to explain how it is that you would be applying 801. And as I've just shown the court, in the context of the controlled holdings, section 801 was the route that had to be used, and the way in which that was justified was on the basis of the conforming interpretation fitting with the other provisions in the UK tax code. And that's why I say the FNR credit must be a credit in respect of tax payable for the purposes of section 790. And there's nothing odd or difficult about this. And you might say, well, it's not credit for tax that was actually paid. Well, there are provisions that recognise that. So, for example, in 788, this is in the context of treaty review, that you can see that the draftsman has thought, this is in the legislation as originally enacted, that there might be situations where there's tax that needs to be treated as having been payable. So nothing was actually payable. tax you would have had to pay but for specific reliefs. And yet that's going to answer to the description of tax payable that's later applied elsewhere in Part 18. The real point I'm making is that that concept of tax payable, it is important for the application of other provisions within Part 18. And if the interpretation is going to work in a holistic way, one has to recognise that if one is reading this credit into section 790, it is still a credit in respect of tax payable. And one then has to ask, well, what are the consequences of that? Now, the Upper Tribunal rejected that analysis because they say, this is really in 193, the principles I've set out didn't require the reference to tax payable in section 790 to include tax at the foreign nominal rate. And they say that for three main reasons, which I'll deal with, if I may, in turn. The first was on the basis, well, nothing has happened under the laws of any other territory. That was the revenue submission recorded at 189, and the Upper Tribunal appears, it doesn't say so in terms, it appears to accept that at 191. So it was said, well, the adjustment has to be under the laws of any other territory. Nothing has changed according to the laws of the other territory. My submission on that is if one looks at 8062, Authorities, page 105. The statutory concept of the amount of any tax payable under the laws of any other territory, that is a UK statutory concept. So we're asking for the purposes of section 8062, what is it for the purposes of that section that counts as tax payable under the laws of any other territory? And what has happened in this case, as a result of the conforming interpretation, is that there has been an expansion in the eyes of UK law as to what counts as tax payable under the laws of any other territory. And there's no difficulty in my submission that that adjustment happens as a result of a UK court decision. So that the first answer the Upper Tribunal gave in my submission can't be right. The second objection was to say that the conforming interpretation didn't involve reading specific words into section 790. That was Upper Tribunal paragraph 193. That is just wrong because of what this court decided in Prudential Court of Appeal paragraph 111. That we have to give a specifiable and specific meaning to the particular provision. And the Upper Tribunal, as I've submitted, has lost sight of the fact that all the credits that are within section 790 are credits in respect of tax payable. And then the third objection was it was said, and this was paragraph 191, that the consequence of the taxpayer's interpretation would be that whenever additional credit is claimed, there would be an adjustment to UK tax. And my answer to that is that the adjustment, it follows from the recognition that the definition of foreign tax payable must include tax at the foreign nominal rate. And what settled that was the judgment of the Supreme Court in Prudential. So it's Prudential Supreme Court that would mark an end point which triggers the 6-year time limit. It's not the case that any time that foreign nominal rate credit is claimed, that would involve an adjustment to tax payable.
Okay, so you say the 8062 period runs from the date of Prudential Supreme Court.
Yeah, or on any view, it can't be any earlier than FIIECJ2, which is when the nominal rate credit is recognised. But my preferred analysis is it's Prudential Supreme Court. And that's a function.
Even though Prudential Supreme Court stated what the law was,
Yes, because going back to Lord Hoffman in DMG, it's a fiction that judges don't change the law. Paragraph 23 of DMG. And there's no difficulty, my lady, in my respectful submission about...
Sorry, why is it the Prudential Supreme Court, what did that establish? It's confirming the...
It's confirming the foreign nominal rate
FNR
credit. Yes.
for
Yes.
portfolio dividend.
Yes. And I can see, but this doesn't matter for Avon's case, there might be an argument that potentially it's the date of FII CJU2, which was in 2012. And if that was the position, Avon would still be in time anyway. So I wasn't going to get hung up on that particular difference. There's nothing difficult in my submission about the retrospective nature of judicial decision-making in this context. And it's suppose there's debate in the UK about, take something like whether a particular overseas levy is a tax at all. I don't know, Swiss canton levy, some very recherché foreign charge. And there's litigation in the UK, and the UK court is persuaded that, in my example, Swiss canton levy counts as tax payable under the laws of Switzerland. The court would be saying, well, that was always the position. If we're taking the declaratory theory seriously, one might also say, well, nothing in Switzerland has changed. But there absolutely is an adjustment in the amount of tax payable under the laws of Switzerland for the purposes of Section 806 sub 2. So that's the...
Well, when you say adjustment to the amount of tax payable, you mean adjustment in the sense of recognising that tax which was in any event payable is credited.
Well, it's what we now know to count as tax payable. Yes, because this is a statutory concept, and one has to look at this in the context of a provision that clearly is intended to enable claims to be made outside that ordinary 6-year period set by 806 sub 1. That's my preferred analysis on that first interpretative question in relation to 806 sub 2. I do also say, and I make this point in paragraph 62 of the skeleton, you can still get there, even if what I've just said is wrong, under reference to the UK computational provisions. So first of all, 795 sub 2, and then alternatively paragraph 8 of Schedule 18. And that would also get you to 806.2 being engaged. But I wasn't going to labour that point given the time. I simply adopt what I've said in the skeleton. So I say that the recognition of the requirement to grant credit at the foreign nominal rate, that increases the amount of tax payable under the laws of the relevant overseas territory. Then I've got to ask, well, is the amount of any credit given under the arrangements, is it rendered excessive or insufficient by reason of the adjustment? And the Upper Tribunal didn't address that question. It didn't need to in the light of what it had said about the scope of 806. In my submission, if this question arises, the answer is straightforward. The credit given under the arrangements, that must include any credit given by way of unilateral relief under Section 790. And so 806 sub 2 is capable of applying. And what's happening now that the FNR is being recognised is that our understanding, take a case involving the German tax, it's a German dividend, the German FNR, we now realise that the amount of tax payable in Germany has increased because it has to include tax calculated by reference to the foreign nominal rate. And as a result of that increase in the amount of tax payable in Germany, a larger tax credit should have been granted by the UK than was in fact given. That's why I say the credit's been rendered insufficient. And then question 3 is, what's the final determination that's material? And again, the Upper Tribunal left that point open. That was UT 197. I don't understand there to be any dispute that if I'm right about what I've said so far, then we're within 6 years, because there's no respondent's notice in relation to that issue. And I simply say the concept of a determination, that's clearly apt to encompass a judicial decision. There's no doubt that a decision of a foreign court is a paradigm example of an event which may give rise to an adjustment in tax payable overseas, triggering Section 8062. Indeed, that was recognised in paragraph 184 sub 2 by the Upper Tribunal. And I say that the preferable analysis is that it's the decision of the Supreme Court in Prudential, but even if it's earlier and it's the Court of Justice, Avon would still be in time because it's still within 6 years. The 8062 claim is still within 6 years of 806 sub 2. So that's issue 6. Please can I deal next with issue 7, which is picking up paragraph 63 in the skeleton. That's dealing with a situation, and this is what the Upper Tribunal dealt with at paragraphs 200 to 208, starting at the bottom of page 183. And put short, what's happened is non-resident dividend income has been returned as exempt in part. So there's a return that's filed in which the EU income is returned as exempt and the non-EU income is returned as taxable. Revenue opens an inquiry and then it closes the inquiry, bringing the EU income into charge. And the Revenue says, yes, 8062 is engaged, but that's only in respect of the EU income. There's no adjustment to tax payable in respect of the non-EU income. And the lead appeal that we're principally concerned with here is Schroeder institutional growth. It is an appeal where potentially it has a number of different routes to recovery, because institutional growth is also the lead appeal for issue 3. And it's also affected, if I'm right about issue 6, it would get home anyway. There's this issue, and then it's affected by issue 8. So the point in issue 7 is, in principle, there can be a valid Section 806 sub 2 claim, but what is the scope of that claim? And the Upper Tribunal says in 206, well, this is halfway down 184, credits are calculated separately by reference to each foreign dividend, so you need a causal connection between the adjustment and any claim which could be made following the adjustment, and there's no such causal connection in the circumstances contemplated in issue 7. Putting it another way, you'll only get within 8062 in a case like this if the income has previously been returned as exempt. And I say there's nothing in Section 8062 that limits its operation in that way. First of all, and this submission is probably actually an echo of what I've just said on issue 6, where 806.2 is engaged, there's no reason why the extended time limit doesn't apply to all double taxation relief claimable in respect of that
So
accounting
all-
period.
All DTR claims within the
In respect of that accounting period.
Why is that? I mean, for example, you've got an adjustment in France,
Yeah.
French court decision. You've also got dividends from lots of other jurisdictions in the world.
Well, but
You're saying it's open season to change.
this is looking, if you're with me that the adjustment to tax payable is an amount equal to tax at the FNR, but I can see that that's an echo of what I've just said on issue 6. So it may be that if that's the position, then I'm not actually dealing with issue 7 in any sort of separate way. What we're interested in section 806.2, it's the credit given under the arrangements, and that must be the credit for the accounting period. And going back to 806.1, what we're interested in is the credit in respect of any income. So I did quarrel with the Upper Tribunal's notion that it's credit for an individual dividend or even for particular dividends. The Upper Tribunal's objection to that analysis was that it was said, well, the taxpayers are depriving of meaning the words to which the adjustment gives rise in section 806 sub 2. That was Upper Tribunal paragraph 206. And I said that wasn't an answer to the taxpayers' analysis, that the claim has to relate to the correct amount of double taxation relief. It's the amount of credit given under the arrangement. The draftsman is interested looking at the tailpiece to 806 sub 2 in whether any, and if so what, credit falls to be given. So that's what I was going to say about issue 7. And as I say, it may be that if I'm right about issue 6, there may not be much work for issue 7 left to do, but it does potentially arise as a separate point. I was going to deal next with the issues concerning eligible unrelieved foreign tax, or UFT. That's issue 8, and then it's also issues B and E, which are closely linked. Address this in the skeleton at paragraphs 64 to 72. In my submission, a combination of the Upper Tribunal's errors in relation to the required conforming interpretation and its interaction with other provisions in Part 18, together with a failure correctly to analyse FII Supreme Court 3, led the Upper Tribunal into error. So issue 8 is in the Upper Tribunal decision, paragraph 209 and following. The key starting point here in terms of the statutory provisions is that youth could be created in 2 ways. The first way is where double taxation relief couldn't be used because of a reduction in UK taxable profits. And that's known as Case A UFT. And if we want to see this in the provisions, section 806 capital A of ICTA is in the authorities tab 7, page 107. And that instance of DTR couldn't be used because of a reduction in UK taxable profits, giving rise to UFT. That's known as Case A UFT, and its nature is described in section 808 Cap A sub 4, page 107. And the amount of Case A UFT is explained in 806 capital B sub 2, page 109. And then the second way in which UFT could be created, which is known as Case B UFT, put short, is where double taxation relief exceeded the UK corporation tax rate up to a limit of 45%. And that's 806 capital A sub 5, describing what Case B UFT is. And then the amount was set in 806 capital B sub 3. And so the first issue, or sub-issue in relation to issue 8, was whether credit at the foreign nominal rate, could that give rise to UFT? And if so, what's the time limit for making such a claim? And that's in the Upper Tribunal at paragraph 209. The Upper Tribunal, reversing the FTT, held that the FNR credit doesn't fall within the UFT provisions. And my submission is that that failed to give effect to the required conforming interpretation, because we know that the credit that's required by EU law must be fed in to the remainder of the UK statutory scheme.
But surely only to the extent necessary
Yes,
to
and I'm going to
meet the EU law.
yes, and I'm going to deal with that, showing the court the provisions. But in principle, one has to ask, looking at the UFT provisions, are they capable of picking up this credit? So what you can't do is create some new regime divorced from the existing provisions to which the FN credit is incapable of coming within. And if one goes back, for example, to section 806A sub 4, and Case A UFT, that's defined by reference to the amount of the credit for foreign tax which is being given under any arrangements. And then for Case B UFT in sub 5, it's the amount of tax which, by virtue of any provision of any arrangements, falls to be taken into account as mentioned, as it happens in 799. And we know that the credit being given under the arrangements is being increased, because in order to comply with EU law, the credit now has to be given by reference to the foreign nominal rate. So the UFT provisions are at the very least capable of applying in relation to the FNR credit. There's a second and separate point, and in my submission a second error that the Upper Tribunal makes at paragraph 218, which is where it held that the FNR credit cannot exceed the UK corporation tax paid on the dividend. And the Upper Tribunal sets that out, seemingly as leading to the conclusion that neither Case A UFT nor Case B UFT could arise in relation to the FNR credit. That must be wrong in relation to Case A UFT, because Case A UFT arises where double taxation relief can't be used because of a reduction in UK taxable profits.
That's in the paradigm management expenses.
Indeed.
Situation.
So that's got nothing to do with the rate.
Well, yes, but in that situation, we now know from SC3 that the DTR gets carried forward.
Yes.
Are you saying you need the UFT on top
Yeah, because what's happening is, that it's not so much that we need the UFT on top. It's that when you look at the conforming interpretation that's been given, the nature of that conforming interpretation is then such that when you look at these provisions, in particular 806 capital A sub 4 here in this example, that provision also applies to the credit that's been recognised.
So as I understand your argument, you're just relying on the statements, effectively the statements in the cases that you apply, once you've done your conforming interpretation of 790, you apply all the other provisions in the normal way. That's the thrust of
That's the thrust of round two, that's right. You have to, we know, because this court has settled, that you're giving a specifiable and specific meaning to the particular provision. And I am picking up the ruling, and here there are no other considerations about retrospective applications or denying claims or any of that. So none of the other issues about construction or conformity with supervening principles arise. And what I'm submitting is that we know that the conforming interpretation is to be made to section 790. We know what the nature of that credit is, and it's 790 that's the gateway then to other provisions in the DTR code. And there's then no reason why those other provisions cannot apply to the credit that is then so recognised. It's no different in principle to what happened in FII in relation to the blending. There was no requirement as a matter of EU law to have a system like section 801. However, it was the result of the conforming interpretation that that system still had to be applied. And that is because what we're engaged in is a process of interpretation, not of legislation. And the conforming interpretation is not making changes to the UK regime other than those that are needed to comply with EU law. Those changes have to be made to section 790, but what one then has to do is to say, okay, what is the result, looking at other aspects of the code. Putting it this way, section 790, it doesn't stand alone. Going back to what my Lord Sir Launcelot Henderson said in FI High Court 1, it doesn't exist in a legislative vacuum. That's the point. There is then a question of principle in relation to case B UFT. Well, on the facts, could you ever actually have FNR credit above the UK rate? And there's no reason in my submission why you can't, because if you look at FII CJU2, what it says in paragraph 62 is simply that the national rules...
That's CJEU.
Yes, yes, FII CJU2, paragraph 62, what that tells us is that the national rules must take account of the foreign nominal rate. There isn't the limitation, as there was in the case of credit for tax paid, to the amount of tax charged overseas, which you see earlier in the judgment. That limitation is not there in paragraph 62 in relation to the foreign nominal rate. I absolutely accept that in Prudential High Court, the case was argued on the footing that the credit would be capped at the UK rate. The reason for that is that what was before the court in Prudential High Court were restitution claims seeking to extinguish the Case 5 charge. In those circumstances, of course, the credit couldn't be bigger than the UK tax liability, but that is a different question to what is it that EU law requires the UK to recognise, and how does that then feed through into the remainder of the UK statutory regime. And I would just add that we saw when we looked at FII Supreme Court 3, and this is particularly paragraphs 132, 140 and 145, that the Supreme Court expressly contemplates that the UFT provisions may themselves have to accommodate the foreign nominal rate credit.
Well, okay.
I appreciate there was no detailed argument on the point.
There's a reference to the existing regime which didn't do the trick in terms of SC3.
Well, and they go on to say that their moulding exercise also applies to the youth regime, actually, to the extent that it prevented the necessary credits from being carried forward. And what they say in paragraph 145 is that the DTR was required to be calculated on a foreign nominal rate basis. That's paragraph 145. And that's just as much the position for the period when the youth rules are in as it is for prior periods. There's then...
I'm still struggling with, I thought you said this isn't... Did you accept that you can't have both youth and the carry forward provided for in SC3? Because the youth provisions were enacted on the basis that there was no carry forward possible.
Yeah.
They provided a partial, limited ability to carry forward and use against other income.
I can see that you can't use the credits twice. So if you would end up using the credits twice, that wouldn't be.
So you think the taxpayer follows? I think that you think the taxpayer can choose between using the youth provisions and what SC3 said was an automatic carry forward.
Well, I think where we are is if the carry forward doesn't happen automatically to deal with the liability, if they're still in time, then they can choose to deal with the matter under youth. The penultimate point on this is a very small point of detail, which I don't want to take up time with. It's simply to say that Upper Tribunal paragraph 221 is referring to the wrong part of FI Supreme Court 3. When the Upper Tribunal says the Supreme Court's concerned with a standstill provision, that was FI Supreme Court 3 201 to 222, but what we were concerned with was what the Supreme Court had said in 119 to 159.
Sorry,
but
please can you just give me those references?
Sorry, of course, it's Upper Tribunal 221.
Got that.
Supreme Court 3 on the standstill is paragraphs 201 to 222. And the Upper Tribunal seems to have thought that that was what the Supreme Court was dealing with, because they say at the end it wasn't concerned with the present issue. And that was wrong, because the Supreme Court did give guidance that's germane to this issue in its discussion of the management expenses point, which is 119 to 159. I'm not going to make a meal of it, though, because I need to be right substantively about what that guidance says. So the fact that the Upper Tribunal got that wrong isn't good enough for me on its own. And then the final point on this issue is whether credit for withholding tax had to be given in priority to credit at the foreign nominal rate. And this is where the Upper Tribunal rejected what was the taxpayer's alternative case. And this was at paragraph 228. The Upper Tribunal acknowledged that there was no provision describing the order in which the two credits should be applied. And in my submission, that being so, it wasn't permissible for the Upper Tribunal to read in a requirement saying the withholding tax had to be applied first. Because that is beyond interpretation, and that is impermissible judicial legislation. there's just one point I'm struggling to find my reference for. Would you be kind of just give me one moment, and I'll hopefully will be able to get it. I've found it, and it's to deal with a point which I'm sure my learned friend would ask me to draw to your attention. I should just address it. It's a provisional view that my Lord Sir Launcelot Henderson expresses on this in Prudential, and it's paragraph 96. So Prudential in Authorities, tab 30, so within volume 3.
I thought I really just left the question open while adopting a provisional approach, just as it were, faute de mieux.
Yeah, what your lordship said was that you'd heard no detailed argument about the order in which the credit should be applied for the sake of simplicity, but without prejudice to the resolution of any issues which may emerge at a future date. I've treated the withholding tax as the first of the credits to be set against the case 5 charge. I thought I should tell the court that at least it happened, but it doesn't in my submission take.
It wasn't part of the ratio.
Indeed not.
I deliberately left the point open.
Exactly right, and we now have to grapple with it. And as I say, the Upper Tribunal recognises, and this must be right, that there is nothing in the legislation that makes provision for any priority or running order as between the two credits. And as I think I say in the skeleton, what the Upper Tribunal actually has done is repeated the Court of Appeal's error in Routier. I mean, I can show the court where the Supreme Court felt that this court had gone wrong in the Routier case, but essentially it's in reading in an additional requirement which, had it been enacted, might have been compliant with EU law, but actually it wasn't compliant. And the Supreme Court says, well, you don't go any further than you need to. In that case, it was enough to disapply a particular restriction. So Routier is tab 46 of the authorities within volume 4. And I'll deal with this very shortly, if I may. It's all to do with whether a trust that was established in Jersey for charitable purposes could qualify for relief from inheritance tax. And what we'll see is that under the UK statutory provisions, the provisions just looked at on their face appeared to apply, whether or not it was a UK trust or an overseas trust. But what had happened was that there was a very long established case called Dreyfus, which had glossed the particular tax provision, and it had said, actually, the meaning that it showed on the face of the legislation, you can see this in paragraph 43 of the Supreme Court's judgment, page 1292. Trust established for charitable purposes only, that had to be interpreted as being implicitly limited to trusts governed by the law of some part of the United Kingdom and subject to the jurisdiction of the courts of the United Kingdom. And that was challenged on the basis of EU law in Routier. And you can see the argument before this court in paragraph 45. So the Revenue accepted that the domestic interpretation, that's including the Dreyfus clause, violated free movement of capital, but they said you could still get to the result they wanted because it was necessary to be able to confirm that the claimant for relief under this provision was indeed carrying out charitable objects. And so what the Court of Appeal said in Routier, you can see in 46, was, yes, you can't apply the limitation in the Dreyfus decision, but it would be justified for Section 23 to contain a right for the revenue to verify information. And that was by reference to mutual assistance agreements. And what you see if you read on, 49, so we should do 48 first. There was no provision in the legislation requiring that. But Lady Justice Arden considered that such a requirement could be read into Section 23 as a matter of interpretation. And that's what's overturned by the Supreme Court. You can see in paragraph 50, this is the Supreme Court's ruling, Lord Reed and Lord Lloyd-Jones. On its face, paragraph 50, section 23 doesn't impose any restriction on free movement of capital. The only relevant restriction, paragraph 51, that's the restriction imposed by the judicial gloss. So that's what had been decided in the Dreyfus case. No doubt between D and E that the Dreyfus gloss was incompatible with Article 56. And then 52, Article 56, directly applicable as law in the UK, must be given effect in priority to inconsistent national law. So you can't apply the Dreyfus gloss insofar as Article 56 applies. And then 53 essentially is saying that is where this court should have stopped. Once it had reached that decision, that would have complied with Article 56, and then 54, a Court of Appeal should not have concerned itself with a hypothetical restriction concerned with the existence of mutual assistance agreements, and that's even if such a restriction might have been justifiable under EU law and might have been imposed by Parliament. That's because there wasn't any such restriction in existence. And you couldn't read it in by means of a purported interpretation. And as a matter of principle, in my submission, the Upper Tribunal has repeated the error that was made by the Court of Appeal in Routier because there was no priority as between the two credits in the legislation.
So do you say it's up to the taxpayer to choose?
Yes. There's nothing to restrict the choice. And in my submission, those errors, they necessarily undermine the Upper Tribunal's analysis of issue B. That's a repeat of the point about whether the DTR credit is capped at the UK rate. That's UT 296. And also issue E, which is whether UFT could be claimed for credit at the foreign nominal rate in the current year. And in particular, in relation to issue E, the Upper Tribunal dealt with that at 311 to 314. It's 314, which is the substantive decision. And I simply say if the youth provisions can apply, one of the aspects of those provisions that must apply is the set of rules in 806 capital D sub 4, 5, and then E about carry back, carry forward, and in-year use. One of the things you can do with UFT is use it in year, if you have it. You can't impose new restrictions on the ability to use UFT when no such restrictions are there in the UFT provisions. That leaves me issue 11, which is the penultimate one of my field points. This was summarised by the Upper Tribunal paragraph 259. It's dealing with a situation where the closure notice brings into charge dividend income which has been returned as exempt, but then that income is offset with management expenses. The question is whether 806 sub 2 is engaged, and if so, in respect of which accounting period. The easiest way of doing this is by reference to the example in paragraph 260. Page 195. So we've got 2 tax years, year 1 and year 2. In both years, the fund's got dividend income of 100, management expenses of 100 in year 1, and there's interest income in year 2 of 200. Now, what's happened is in the tax return, the fund's shown the dividend income as exempt. And what that means is there's no income in year 1 against which to set the management expenses. So you've got 100 of management expenses in year 1 carried forward and set against the income of year 2. So rather than a profit, so there's a net taxable profit in year 2. Closure notices then are issued, and that's what the Upper Tribunal picks up in point 4. Year 1, the dividend income of 100 is treated as taxable, but that's offset with management expenses of 100. And then year 2, it's now said there's income of 300, but then there are no management expenses available because on the analysis in the closure notice, those management expenses have been used up in year 1. And then the revenue says no double taxation relief on the dividend income, so taxable income in year 2 is 300. And what the fund then does is it claims double taxation relief at the foreign nominal rate in year 1 and year 2, but it needs the section 806(2) period. And I make 2 submissions on this. I say, first of all, and this is a function of the correct interpretation of FI Supreme Court 3, first of all, the additional double taxation relief, that carries forward automatically. That was FTT 199, so that's one route into section 806 sub 2. But if that's wrong, my submission is that the reallocation in the closure notice of the management expenses from year 2 to year 1, in any event, that adjusts tax payable in the UK, and that triggers section 806 sub 2 in any event. Now, what the Upper Tribunal said about that submission was in 267. They said there's no causal link between the amount of double taxation relief credit in year 2 and the tax adjustment arising from the management expenses being carried back. So they accepted there was a higher level of UK tax in year 2, but they say that didn't cause the DTR credit in that year to be insufficient. And my submission is that's not a realistic analysis of what's going on here. On the return as originally filed, there was no credit needed in year 2, and that was because the management expenses were being applied against the income in that year, and that's what one would expect under the ordinary operation of section 75. What's happened under the closure notice is the management expenses have been taken out of year 2 by the revenue and they've been applied in year 1. And what that reveals is that there is additional tax payable in the UK in year 2, and there is then taxable income that should benefit from a credit, but which didn't. So what I'm saying is that in that example that's set out by the Upper Tribunal, the closure notice has the effect of increasing the tax payable in the UK in year 2. And what that does is it renders the credit given under the arrangements insufficient. That's why I say on any view, section 806 sub 2 is engaged in year 2.
If HMRC are correct on issue 10,
Yep.
and you need a year 1 claim,
Yep.
does it follow that you can't win on issue 11?
No, because I've still got the adjustment in year 2 under the closure notice.
That presupposes that your credit is carried forward from year 1.
Well, what I'm saying at this stage of the argument is that we know in year 2 there wasn't in the return as filed understood to be any unlawfulness. So there's the automatic application of the management expenses, so there aren't any taxable profits, so there's nothing to claim.
No,
But-
well, probably talking at cross purposes.
Well, I'm sorry.
Maybe you could take, because I'm conscious of time, if the revenue win on issue 10,
Yes.
which is that you need a DTR claim in year 1
Yes.
before the DTR can be carried forward,
Yes.
does it follow that this point on issue 11 falls away?
I didn't think that it did, because I think you've
Well, maybe you
but
could
perhaps we
reflect on
may
that.
need to
Thank
come
you.
we may need to come back to that. The last point I should just address on the appeal is issue A, which I think is the very last point in the skeleton, and it's not really a substantive matter. It's 74 and 75. As if there is a closure notice, is the revenue bound to comply with the findings when it issues the closure notice? And as I say in 74 and 75, the answer in my submission is yes, it is, because the jurisdiction of the tribunal is to decide questions of fact and law that are incidental to the closure notice application. So if the points have been decided, those decisions should be being reflected in the closure notice. That submission was rejected by the Upper Tribunal at paragraphs 289 and 90, albeit obiter, because of course the Upper Tribunal wasn't ordering the revenue to give closure notices. I'll leave, if I may, additional issue C, which is Milan Friends appeal, and until reply. I adopt, of course, what I've said in the skeleton. But those are my submissions in opening, unless the court has any more questions for me.
No, thank you. Mr. Young.
Can I just get set up? Good afternoon. What I was proposing to do was to begin by, very much as I think my learned friend did, was by taking you through the various authorities chronologically in order to put all of these points that my learned friend made in context. I think it's important to look at the context. I can do that much more briefly than I was expecting, because my learned friend has referred to a lot of the provisions and the paragraphs that I was going to refer to, but I think you'll find that I don't agree with the characterisation that the taxpayers put on some of the what happened in the past. Can I just start by the context, which were EU law challenges to UK taxation provisions, and they went beyond the two GLOs that we've been talking about so far, which was the FII GLO and the CFC and dividend GLO. At the same time, at roughly the same time, there was also a GLO started in relation to loss relief. That's the surrendering of losses within groups of companies. And the argument there was it was possible for non-resident companies to surrender losses to UK resident companies, with the result that UK resident companies had less profits and therefore less tax liability. And that was the litigation that was dealt with in the Marks and Spencer case, which you've probably heard referred to. The only case which actually came out of the GLO was Autologic, which was the case that my lord Sir Launcelot Henderson has had to look at a few times, which was a procedural case about whether you should go to try the statutory regime before bringing common law claims. So there was that GLO, and there was also the thin cap GLO, which concerned payments of interest by UK companies to foreign group companies, essentially, and the deduction of what level of interest was permitted to obtain deductions. And that GLO went on until 2011, when the Court of Appeal, this court, decided that there was no unlawfulness, in fact, in the provisions as they stood. But it was bubbling along in all the period we're dealing with. And there were other challenges, and more ad hoc challenges under EU law being made. I simply make this point because when we come to look at something like the business brief, it's wrong to think that this was aimed at simply these GLOs, the two that we're dealing with. There were a whole lot of possible and actual EU law challenges going on. So the first case that I was proposing to look at chronologically was Metal Gazelle Shaft, which I think is in bundle 5, tab 57.
That's the case I always refer to as Hearst.
Hearst, yes.
Take up less room on the paper.
Yeah,
It's the same one.
it's the same case. In this particular report, Metal Gazelle Shaft comes first.
Yeah.
So I think that's,
It used to be the other way around.
it used to be the other way around, yeah. But it's Hearst. And it's the case, my learned friend's taken me to this. It's the case about advanced corporation tax and whether a company, a UK resident company, could make a group income election with its foreign parent company. And of course the consequences of them being able to do that would normally be that there would be no ACT paid in the UK at all, because the effect of the group income election is that the UK company wouldn't have to pay ACT, and of course the parent company would never be liable to ACT. So that was obviously, as you can see, why the revenue didn't think this was a very good idea. But the European Court held that denying that right to elect was a breach of freedom of establishment. There were two issues being dealt with in this case, quite separate issues. The group income election issue, but there was also an issue about tax credits. And that was broadly a situation where a UK company paid a dividend to a foreign parent. Under certain double tax conventions, they could claim a credit, a payable tax credit from the UK. And there were a number of arguments along the lines of you ought to be able to get the best credit available in the EU. The most favoured nation, I think it was referred to, type argument. So those who were not able to get a credit because the double tax treaty didn't provide for it, or who were getting a smaller credit than other countries, were complaining about that. Now, what happened in the European Court was the parties all said to the court, this issue only arises if you decide against the taxpayer on issue 1, which was the group income election. Having decided for the taxpayer on issue 1, you would see that the court didn't deal with the tax credit issue. But I only say that because you will see mentioned in, I think, question 5, tax credits are mentioned. That's a reference to the other issue that wasn't dealt with. It was eventually dealt with in a case called Class 4, subsequently, where there was a reference made specifically on this point. I think I think my lord perhaps made the reference, in fact. And the answer was, no, they couldn't have these credits. So my learned friend took you to a passage, paragraph 98 and following in the judgment. And this concerned what you might describe in some contexts as questions of mitigation. The question was, would it be permissible under European law for the UK to be able to run an argument that the amounts of restitution or damages which they were entitled to ought to be reduced because they didn't take all steps that were possible under domestic law to claim the group income election. That was broadly the argument that was being put. And of course, this was an argument in the context of claims in restitution and damages. And the answer to that was, no, you can't. The court said that was not something that they could argue in response to a San Giorgio type claim or a claim for damages. And this was partly based, you will see, from paragraph 104, from the particular oddities of the group income election provisions. Because if you made a group income election and it was refused by the inspector and you appealed, and until the election was granted either by the court or by the inspector, you could still not pay dividends without paying ACT. In other words, you were still obliged to pay ACT. There was, in other words, there was no retrospective effect of winning an appeal against the refusal of a group income election under UK law. And that's different, of course, from other claims that we're dealing with here, because other claims, if you make a claim for group relief and the inspector denies it and you appeal, if you win, then you get the benefit of the claim from essentially day one. So there's no period in which you don't have the claim. So it was based to some extent on the unusual nature of the group income election procedure. But this says nothing about, we would submit, says nothing about the kinds of claims we're dealing with in this appeal. This was an argument about, as I say, about something along the lines of mitigation in relation to claims and restitution.
Well, I understand the point you make about the context, but would you accept that the principle stated in paragraph 106 is a more general one?
If you've got a claim for restitution or compensation, then you can't reduce it. I agree. I would accept that. Yeah.
Yeah.
But we don't have claims for restitution or compensation in these appeals. So it's not a principle that has any relevance. While we're in this case, can I just take you to paragraph 85? Because that is central in my submission to the arguments in relation to European law in these appeals. It is this fundamental rule which is repeated in many cases. I only take you to this because it's convenient. And you'll see even by 2001, it was already settled law because there's a whole lot of cases cited for it. So what that's saying is, since there are no community rules on restitution and national charges improperly levied, it's for the domestic legal system to designate both the courts and tribunals and to lay down the detailed procedural rules governing actions for safeguarding rights which individuals derive from community law. provided that such rules, what the European Court is saying is it's such rules that you have to consider whether they comply with the principle of equivalence and the principle of effectiveness. And if they do, then they are perfectly valid, and those are the rules that apply. So one has to look at the rules themselves to determine it. In other words, you don't look at the position of a taxpayer now and say, or at any point, and say, well, they can't make use of these rules because they didn't understand the law, for instance, and therefore that's a breach of effectiveness. The point the court's making here is, look at the rules. Do they provide an effective remedy? And in my submission, the rules, the UK rules, provide an effective remedy in a number of ways. They provide a remedy, in the context of this case, they provide a statutory remedy for claiming DTR credit. And on top of that, the icing on the cake, they provide restitutionary rules or restitutionary remedies, which are wider and more generous, possibly, than the statutory remedies, and have a potentially more generous limit, or had a more generous limitation period in claims and mistake. So looking at the entire system, which is something which you are required to do under European law to determine whether it complies with European law in this aspect, we would say that there is more than enough effective remedy, a plethora of remedies.
Well, there was a long period, wasn't there, when the revenue were denying the availability of anything other than the claims, various statutory claims. Isn't that right? I mean, the availability, have I got this the wrong way around? The availability of the state-based restitution claim was a very live issue until it was finally, I think, the first visit to the Supreme Court, which finally settled it.
DMG decided that these restitutionary claims applied to tax.
Yes.
So that was an issue up until,
Yeah.
you might say,
Yes.
up until
Yes, that's right.
up until then, but they decided that that was the case. And
was there also an issue about how many remedies the domestic system needed to provide, or
that was an issue, and I'll come back to that. That was an issue which arose in relation to the questions about the Section 320 and Section 107. You remember what happened, sorry, but for those who were not been involved in this for 20 years, in 2004, the government introduced a provision which is called Section 320, which you'll probably have seen mentioned, unfortunately without a transitional period, which said that claims in mistake from that time, which were made on or after that date, didn't have an extended limitation period. And then subsequently, they introduced a provision which said all claims, whenever made, don't have an extended limitation period. That was Section 107. And those were the provisions which were being challenged in the first round of one of the things your lordship had to decide whether they were compatible with EU law. And your lordship decided they weren't. The Court of Appeal decided they were, and the Supreme Court decided they weren't. Well, one of them wasn't, and the other one was referred to the European Court, and it decided that that was not compatible either.
Yeah.
So the net result was they were all held to be non-compatible because they were taking away rights without an adequate warning. Because when the provision came into force, immediately the rights, extended limitation period rights, disappeared. That's right. And in the context of that argument in the Supreme Court, we had the rather bizarre sort of situation where the taxpayer was arguing that they didn't have a Woolwich claim for various reasons. And that was because the revenues argument was that the Woolwich claim was sufficient to satisfy effectiveness.
That's what I looked at the back of my mind.
That's right.
Yes.
Yeah, but the estate claim was still there. It didn't, but the extended limitation period had been taken away.
I see. So it
Yeah.
had no practical use, although it was, or at least if had the argument succeeded, it would have.
Yeah, yes.
And of course,
So the argument,
limitation
the
period-
revenue was saying there was an effective remedy as regards common law by the Woolwich claim alone.
Yes.
And although all the points that the taxpayer raised as to why Woolwich didn't apply were rejected, they went on to say it's not good enough to have one remedy. If you have two remedies, effectiveness applies to both remedies individually, and you can't take away, you can't restrict one of them. And that's what the European Court, I think, confirmed in the third reference. That's right, yeah. Yes, but what we're looking at here is what remedies are available. And there's certainly, throughout the period, there was a 6-year remedy for without any doubt, under Woolwich and mistake. In fact, there was a longer period until 2010, which I'll come on to, where all common law claims were no longer permitted to recover tax. That's the ouster in 2010. I think it's also true that Section 320 continued to apply validly in relation to situations where the rights arose after it was brought into force. Because you weren't taking away anything then. So if someone paid a dividend 2 days after Section 320 came into force, Section 320 would apply to it. Because the rights only arose after Section 320 was in force. And so Section 320 is still in force. The vice was taking away accrued rights, not, the provision itself was not completely invalid. Sorry. So we say that the inquiry is as to whether the provisions, the statutory provisions of the common law and or the common law provisions provide an effective remedy. And we say that's a simple starting point based on what is a paragraph which your lordship will be familiar with, and it appears in almost every tax case, in fact, including FII.
The one about effectiveness and equivalence.
The one which says it. Well, the one that says it's
domestic.
It's for domestic courts. Yes, exactly. That paragraph 85 in Hurst. So,
and for dozens of cases, including the ones we've already mentioned, one finds that paragraph repeated, and there the overriding principles of EU law which applied. It's certainly then.
Yeah.
We didn't really need to go on to consider legal certainty and or
yes,
verdicts and all the rest of it. They were really regarded as the underpinning overriding EU principles which had to be observed by the member state.
yes, and I quite accept that there can be situations where a member state can breach legal certainty, and an example might be where, let's say, the Supreme Court did what the Spanish Supreme Court did, which was to say, have one set of procedural rules for appeals. Someone made an appeal under those rules, and then the court retrospectively changed the rules so that the appeal which they had made under the old rules was no longer valid. And you might say, sorry?
Was it Italy?
I think it was Spain. Right.
Oh, never mind.
But anyway, it doesn't matter. So the domestic courts can create a situation where there is legal uncertainty, and now what the result of that is, I'm not expressing a view. But what we say about this case, this situation, is the courts and the UK legislation do not create any uncertainty whatsoever. If there was any uncertainty, it was only created by the decisions of the Court of Justice themselves. So can I then take you to the first reference, which is 2006? And that's, I think, in your bundle 6, tab 62. And it's page 1840. 1841. And my learned friend is taking you through this. I only want to draw attention to a couple of paragraphs. One is paragraph 53. Which makes the point that the fact that an imputation, compared with an exemption system, an imputation system opposes additional administrative burdens on taxpayers, with evidence being required, etc., cannot be regarded as a difference in treatment which is contrary to freedom of establishment. Now this point is picked up in Haribo. One of the issues in Haribo was, does it cause a problem where you have an imputation system in relation to, I think in relation to portfolio dividends, where the evidence was that it was impossible or excessively difficult, certainly impossible perhaps, for the taxpayers to find out the actual amount of tax paid by the company from which they receive the dividend. Of course, this is a problem for portfolio dividends, because if you only have a 1% or even less shareholding in a company, you're not going to be in a position to influence the company in order to provide you with the information as to what the profits, its taxable profits were in foreign countries, in order for you to claim double tax relief. And my lord, again, may remember that in Prudential, this issue arose, although it became academic because your lordship decided that they could claim at the foreign nominal rate. But you did consider the question as to what happened if they had to claim for tax paid, and whether that was a problem. And you concluded, quite, we would say correctly, that Haribo decided that was not a problem for the member state, for the UK in this case. It was simply a feature of the imputation system, that you had to prove the amount of tax paid. And that was the case in Haribo, both in relation to situations where the legislation actually provided for the credit. But it was also the case for situations where the legislation in the Haribo did not provide for credit in relation to third countries outside the EU, but the courts in the country, I think, was it Holland, the country in question, anyway, it doesn't matter, the courts there had decided, as a matter of what we would call conforming interpretation, that there should be a credit for tax paid in order to comply with EU law. I don't know if you may remember that, but anyway, the point was that it wasn't just in situations where there was actually a legislative provision to provide for the credit. And you decided that, and in Class 8, Mr. Henderson attempted to persuade the Chancellor that you were wrong in that, in that point. But the Chancellor said, no, you were right, and he came to the same conclusion about Haribo.
It's one of those rather austere conclusions. It looks a bit tough when you think of the practical repercussions for taxpayers. On the other hand, it just reflects the economic reality of the situation where you have a portfolio holding.
Yes.
Most of us have small shareholdings in a number of companies.
Exactly.
It cross our minds to begin asking for details of the underlying tax paid on foreign dividends.
Yes. And the irony of the situation, of course, was that in trying to defend the provisions, the UK and other countries had said, well, the reason we do this is because it is actually impossible for them to find it out. But the taxpayers said, well, that doesn't matter. It's still a breach of Article 56 to deny us the right to the credit. So that is, in my opinion, illustrates the position under EU law in relation to administrative requirements, such as having to show the tax paid. The other provision, the other paragraph I just wanted to show you, it's quite important, is paragraph 74, which is the decision in relation to portfolio dividends. And what that says, now, sorry, can I just wind back a second before we look at this? The context of this, of course, is that in relation to what we might call controlled dividends, I think that's been referred to, i.e. not portfolio dividends, the court had already decided in issue 1 that it was going to refer back a question to the National Court to determine whether the situations were equivalent. Now, the oddity of that, and this is something that I'm sure came up in arguments many times in the past, but the oddity was that the European Court, in dealing with issue 1, didn't do what it always does in relation to tax provisions, which is follow the structure of restriction, determining whether or not there is a restriction. If there is a restriction, considering whether it was justified by one of the justifications recognised, and if it was, considering whether it's proportionate. That is the way that the court will always will deal with the situation, because it has to, having determined there's a restriction, it has to address justification. Now, the oddity is it didn't do that in relation to issue 1. Now, whether that was because it felt that it thought the answer was going to be that everything was okay, and it didn't need to consider justification, I don't know, we'll never know why they did it, but that's what they did. And when the case went back, you remember they did consider justification and proportionality, which is where we got the foreign nominal rate from. And the oddity is that the revenue had raised fiscal cohesion as a justification the first time round. So it had said, even if there's a restriction, it's justified on the grounds of fiscal cohesion, which is the ground on which the court, the second time round, decided the case. Anyway, in any event, we're in a position where, in relation to FII type situations, group situations, the matter has been referred back, because of course in those situations you have credit for tax actually paid under either double tax treaties or unilateral relief. And I just want to mention, I'm sure two of the court at least will probably be aware of this, that this is not unique to the UK, this system of providing double tax relief for tax paid for 10% or over. It is almost universal, a matter of international tax. If you're providing an imputation system, it's provided by way of, if you look at any double tax treaty, you'll probably, or many, you will see the same provisions. So it's not just the UK that has this idea that 10% or less don't get any credit for underlying tax and 10% or more do. So what the court said in paragraph 74 is Article 56 precludes legislation on a member state which exempts from corporation tax dividends which a resident company receives from another resident company, so that's section 208, where the state levies corporation tax on dividends which a resident company receives from a non-resident company in which it holds less than 10% of the voting rights, without granting the company receiving the dividends a tax credit for the tax actually paid by the company making the distribution in the state in which the latter is resident. So just reading that at the time, well, it was at least a likely conclusion that you might come to. But the vice here was the lack of the right to a tax credit, the tax actually paid by the company making the distribution. I'm not suggesting that was definitely the answer, and of course we know that the answer was something different subsequently. And I'm not relitigating the argument which was taken to the Supreme Court about what the effect of these judgments is. But I'm simply making the point that if you read that paragraph and as a conclusion from the reasoning, it's at least one strong possibility that the problem is lack of double tax relief credit for tax actually paid.
And the relevance of that is what? Because on this point, you seem to be in agreement with Mr. Bremner that we shouldn't be rewriting history.
I'm sorry, I'm not sure I follow quite what that question means.
Well, how does it help us to be reminded, for some of us, or informed for me, that there was a tenable interpretation back then, which subsequently turned out to be wrong?
This is all in the context of, and I'm going to come on to this, of the submissions my learned friend made about what was understood at the time. Now we say, but can I make it clear? We say that doesn't matter. It's not relevant to the issues. The issues have to be determined on the basis of conforming interpretation and application of that to the facts and to an objective view of what the taxpayers were doing. However, I feel, unless you say this is a hopeless argument, my learned friend, I do feel I have to address the points he was making about, because it does seem to be part of my learned friend's case that what they did was in line with what everyone thought at the time, including the revenue.
In his written submissions, it say basically we made every claim we could think of.
Yes, but I think in
you're responding to that submission.
in oral submissions, I think he talked about doing what was reasonable. Well,
Yes.
Yeah.
It was put differently.
yeah, I'm responding to that submission, but I'm also responding to the submission that suggestion that everybody until 2012, everybody thought that the answer was exemption, and that's not factually the case. Can I just summarise the revenue? There was a different position in relation to the FII case and the portfolio holdings because of the fact that in FII there was credit given for tax actually paid. So the position of the parties in FII, and we'll see this in the litigation, was the revenue said there's nothing wrong with the regime. And that should be the conclusion the European Court, how you should interpret the European Court decision. There's nothing
Right,
wrong with the regime in relation.
Sorry to interrupt, just so as I got the thought, clarify the thought in my own mind. As I understand it, what you're saying is that your primary position is what people thought back in 2010, or perhaps more relevantly 2008 or so, is irrelevant. But you say if contrary to that it might be relevant, you don't agree.
I don't agree with what it was said about
Yes.
the characterisation of the positions of the parties. Exactly, that's precisely.
Yeah.
And I'm summarising now what I say was the position in the litigation and explaining why a particular issue arose, which my learned friend relies on to some extent, Section 33 issue. So the position of the parties was quite stark. The revenue said the legislation was compatible and fine. The taxpayer said, no, it's unlawful. No question of tax credits, because there was a tax credit for tax paid. That's not enough. The legislation is unlawful. And the answer, essentially, therefore, is an exemption to be granted. And it was on that basis that we were arguing the case. We were not arguing for exemption, obviously. We were arguing that it was perfectly valid. That was the position up to 2012 when we had the second reference, and of course everything changed then because the FNR came in. But throughout the first round of litigation, which I...
So, sorry, presumably after this case we're on at the moment, which is the first reference,
Yes.
HMRC accepted that in the case of portfolio dividends, underlying tax credit would be available for tax paid.
Exactly.
Subject to the problem that you can't find it out.
Exactly.
But in principle,
So the position in relation to portfolio was that the taxpayer was saying, I think, generally exemption primarily, and probably because for the reason that your ladyship suggests, the revenue was saying no. Look at this paragraph. Look at the decision. The answer is a credit for the tax.
so going back to the extent it might be relevant to the letters and claims and so on, when they're all put in on an exemption basis, you would say, well, that might have been what the taxpayer's position at the time was, but it certainly wasn't HMRC's.
Exactly, and so the evidence, and this is something that we may have to show to you now, if this is relevant. A number of witnesses gave evidence in the First-tier Tribunal. All of them gave evidence that they took these decisions on professional advice as to what they should do, and their decisions not to bring common law claims were based on their circumstances and the costs, and whether they thought they could get it more cheaply by making statutory claims. So that was the position they took. All of them were asked in cross-examination whether they knew of or had understood the revenue's position at any point to be exemption, and they all said no. Including it was not. They all said it was not. They understood that they agreed with me that was not the position, including Mr. Anderson, who was employed by the solicitors running the litigation, who was giving evidence generally about the litigation, so had an overview of all the litigation. So that was the position. As regards the position in this case, there is actually some evidence about this in the bundle, in one of the witness statements. I don't know if your ladyship has seen this. This is the taxpayers' unagreed but possibly now agreed bundle of documents.
Because you're the only person who's taken it.
Well, I thought it was very useful.
So where do we look?
It's page 62 of this bundle, which is behind the tab 3, paragraph 23.
This is someone at Fidelity.
This is Fidelity. And what they're saying is that she was aware. This is Elizabeth Taylor was aware. In response to the decision of the ECJ, HMRC pursued the argument that the dividend income should also carry credit for tax paid on the underlying profits. And then Fidelity did make a claim you'll see in 31st March 2010 on that basis. And of course, if you think about it for a moment, it's obvious that the revenue would not be, if the revenue was taking the position that the income was exempt, then that would have been the end of the litigation, because the parties would have been in agreement. The taxpayer said it was exempt, the revenue said it was exempt, yeah, that's it. So it wouldn't make any sense, but that wasn't the position. And that's the paragraph that the Chancellor was referring to when he said that the parties would be deemed to be aware of the double tax credit. And I think what he meant by deemed was that
Sorry, you're too
in Class 8, this is in Class 8, yes, my learned friend took you to that. I think what he meant by deemed was, even if they didn't read this, They ought to have known. I think that must be what he meant.
Sorry, can you remind us of the paragraph number?
Sorry. Sorry. 83. I think 83.
Thank you.
So I was then going to take you to Vodafone. So that's simply chronologically the next case. I might have time to deal with the first. I was going to deal with both. There are two decisions of the Court of Appeal in Vodafone in the bundles. The first of these is relevant to the question of the closure notices. So I thought I would just take you to that now. And it's in bundle 1, tab 24. It begins on page 262. So Vodafone concerned the Controlled Foreign Companies legislation, which for those who don't know about it, broadly concerns situations in which a UK parent has a subsidiary which is resident in a low tax jurisdiction. There are a number of other conditions. One of the conditions is that there should be some kind of tax avoidance, or I'm using tax avoidance very broadly. I know it's not quite accurate. It's about diverting profits from the UK. But taxpayers were saying at this point that legislation was incompatible with EU law in relation to subsidiaries in EU countries. And there was another case called Cadbury Schweppes, which concerned an Irish subsidiary where the rate of corporation taxes was relatively low, which had been referred to the European Court. Now, what happened in Vodafone was also an inquiry by the Revenue under the CFC legislation. And as part of that, the Revenue issued a notice to provide documents and information. The taxpayer responded by issuing a closure notice application. This is an application which asks the First-tier Tribunal, in the first instance, to direct the Revenue to close an inquiry within a certain time. Usually, this provision is used in situations where the Revenue have been asking for information, and eventually the taxpayer says, look, you've got enough information. you either issue a closure notice or you give up. And they go to the tribunal and get a direction, well, they can get a direction. That a closure notice should be issued within a certain period. As I say, that's the normal case. However, Vodafone were using the procedure in a rather novel, imaginative way. What they were saying was, your entire inquiry is now based on the CFC legislation. We say the CFC legislation is unlawful under European law. So no matter what you do in this inquiry, you cannot impose any tax charge on us. And therefore, as a result of that, the closure notice must be ordered because the inquiry must be brought to an end because it's pointless. And their argument was that we've got a legal knockout point. We will have to make a reference to the European Court to establish it, but still we've got a legal knockout point. And the Revenue said, no, it's not open to taxpayers to do that for various reasons. And that was what this litigation is about. And it went to the Court of Appeal. And the Court of Appeal said, yes, they do have jurisdiction to decide legal points, which are, if you like, a knockout blow, and mean that the inquiry shouldn't carry on. And you can see this in the discussion, particularly paragraph 21, which is on page 270. Where they say, para 33 on its face, however, would seem to confer on the Commissioners a power to do anything that the Commissioners reasonably consider necessary to enable them to be satisfied as to the matters required by that paragraph. That interpretation promotes the effectiveness of para 33, which we presume Parliament wished to achieve. On that basis, it's legitimate to put the question the following way. That is to ask whether there's anything in the wording of paragraph 33 to suggest it does not confer jurisdiction to decide incidental points of law. That is, points of law that need to be resolved in order to decide whether there are reasonable grounds for not giving a closure notice. So the points of law are very restricted. They're only points of law that would lead to the conclusion that there should be a closure, or there should or there shouldn't be a closure notice. So if the taxpayer wins a point of law, then there should be a closure notice because there is no reason for the inquiry to continue. And they went on to decide that there was nothing in para 33 which negatived that, and therefore they were able to do it. And a reference was made in Vodafone 2 subsequent to this. However, before it was decided, in fact, before I think even the observations had been made, Cadbury Sweps reference, the decision came out, which made the Vodafone reference OTOs. So I think in the end it was withdrawn. But that led to the second round of litigation, which is the litigation in which the more famous Vodafone 2 decision happened. Because what then happened is that the European Court decided in Cancery Chamber that the legislation would be valid if it allowed a let out for situations which were not wholly, when there was not wholly artificial arrangements. I'll come on to look at this in more detail possibly tomorrow, but when there were not wholly artificial arrangements. And the argument then in the domestic courts was, can the legislation be given a conforming interpretation, in which case the inquiry would continue because there would be legislation in force, or was that not possible? And therefore the legislation would be disapplied and the inquiry would cease. And the special commissioners on the when they came back decided that a conforming interpretation could be given. I think by a majority. I think it was a casting vote, in fact, in memory. On appeal, Mr. Justice Evans Lawman decided that it could not be. There could not be a conforming interpretation, and therefore there was disapplication. And then on the final appeal, as it happened, to the Court of Appeal, they decided there could be a conforming interpretation. And it's an important decision which I was going to look at next.
It's quite well known, so I think you can do that quite briefly before we finish today.
Okay, fine. So it's Vodafone 2. Put it here. It's in tabs. Oh yeah, sorry. It's right at the back. Tab 70. It's in the final.
I mean, the well-known passage is from the judgment of Sir Andrew Morritt, where he summarises the learning on conforming interpretation.
Yes, but what I also wanted to look at was how he dealt with the objections that were made by the taxpayers, because you see they made a number of objections. In paragraph 40, they didn't disagree with the statements of principle which are set out above.
Yep.
They made three submissions that it wouldn't conform with the scheme and essentials of the CFC legislation. Such an interpretation would create two regimes for those within the, I think they mean EU and EEA and other elsewhere, and any such interpretation would be retrospective in its operation of all legal or economic policy decisions, fail to satisfy the test of legal certainty. So it's what Sir Andrew Morritt said about those that I was wanting to just draw attention to. And if the court would just like to read, I mean, either now or if you want afterwards, paragraphs 54 to 59.
You say 54, do you mean 55?
Well,
55,
sorry, 54 was just his conclusion about the geographical scope. Yes, 55.
We're not really concerned with the geographical aspect in this case, are we?
No.
Whereas the point about retrospectivity is front and centre.
Yes.
Yeah.
But the points about precise formulation and also about an interpretation which reflects the operation of precisely the element the Court of Justice held to constitute the hindrances are important as well.
All right, very good. We'll pause there and resume 10:30 tomorrow.